it's always something that bothers me. It's like you see like the women screaming and like the doctor running in, and like there's this like stereotype of what, I don't know, like what we've turned birth into in cinema. And yet at the same time, it's beautiful because you're giving life. But, you know, for me and my wife, we had a beautiful experience with birth. Wow, it was also painful. I mean, my wife was in labor for, 36 hours. And so I wanted that birth scene to feel so real and beautiful.
Hi friends, it's Katie from Without a Crystal Ball. Welcome back to my channel. I'm having a hard time with this case with Lively and Ryan Reynolds and these PR agents. If I have learned anything in this case, that is that some of these PR agents are the slimiest human beings in the world. I cannot imagine being a part of an industry that literally for a living helps people like Blake and Ryan and other people like the Duggars or Cody Brown, you know what I mean? Awful humans. I mean, even Leslie was Harvey Weinstein's publicist. Let's not forget that. These people that, their job is to push out positive stories about someone and reduce and bury negative stories. And Ryan and Blake have a lot of money to bury stories, and Leslie Sloane has a lot of influence and pushes and promotes and tries to get her clients buried, all the stories that are bad about them buried. And for years, it worked so well for Blake and Ryan because we rarely saw any negative press. Now the mask has slipped and we're getting it because courts show the truth. And Leslie Sloane filed a motion to compel for Justin Baldoni to produce documents and demand that he answer interrogatories. And this motion to compel feels strategic in that it's premature. We are only 2 weeks out from when the production and interrogatories deadline. So when they were served the interrogatories and when they were served the production of documents requests, they had to submit them, and they have a right to object to requests. After the objections to the requests go through, then they're supposed to meet and confer and work through their differences before bringing it to the court for the judge to get involved. In my experience, I've gone through multiple lawsuits. Judges hate to get involved in motion to compels, and they don't like to sanction if it's, not, if it's too early. Like, say if a judge says, I don't think you've really spent enough time working through this and you're bringing this kind of prematurely, and I'm not going to compel anything. You need to work out your differences. They won't sanction Justin. They're not going to sanction Wayfair. That's been my experience. I've had to go through discovery, and I waited 2+ years and still didn't get all the documents I needed in my case. So when I look at her filing a motion to compel after 2 weeks, knowing that the discovery due date for everything, the hard cutoff is August 14th, this filing by her feels strategic in that she's able to post what she asked him to put out. She's able to degrade him and to disparage him. She's able to try to accuse Melissa Nathan of wiretapping after they accused Stephanie Jones of wiretapping. And what this feels like is both one, strategy in order to get in front of the judge because the judge hasn't ruled on motion to dismisses yet, and they want to tell the judge, see, hey, they don't have any evidence. Please, please, please. This is proof that they don't have evidence. And then secondly, to just further rip him in the media. So in her motion letter by their attorneys, it says, after 4 months of dissembling and issuing vague and inconsistent statements through their attorneys, the Wayfair parties have yet to identify the basis for their claims against the Sloane parties, including but not limited to the statements they claim defame them or put them in a false light, when or how those statements occurred, and to whom those statements were made. And that's not true. It's in their documents. It's in their complaint that she contacted the Daily Mail. She began putting out a series of stories. They have text messages from the Daily Mail journalist that received the tip from Leslie Sloane directly and what she said was happening on the set. And it was Leslie that was putting that out. And so Leslie knows what she's done. And it's just ridiculous that this is happening. But again, I'll get back to it. As set forth in the Sloane motion to dismiss, the Wayfair parties are required to, but did not provide this information in their complaints, and they're not required to. The Wayfair parties' opposition brief provided no further specifics, stating only that they know and allege that Sloane made statements to reporters referring to Baldoni as a sexual predator and accusing him of sexual assault, and seeded false information about Baldoni in the Daily Mail in an effort to divert negative attention from Lively. The Wayfair parties somehow made these factual assertions despite previously including in their now dismissed California action against the New York Times an image capture of a Daily Mail reporter conceding to Brian Friedman and Melissa Nathan that I had many conversations with Sloane about Blake, and never once did she say anything about sexual assault. Because Ms. Sloane denies ever referring to Baldoni as a sexual predator or accusing him of sexual assault, she is unable to meaningfully defend herself without knowing what the Wayfair parties accuse her of saying and to whom. So that whole sentence and that whole paragraph, to me, having gone through litigation myself and knowing that she wants out of this, is her trying to remind the judge that, hey, I filed a motion to dismiss. Do you remember that? Do you remember I filed it and we finished it a couple months ago? Well, listen, judge, I want to remind you that I filed that and it was really great. And I want to remind you of the points I made that they didn't have evidence and they were really lacking in their evidence. And I want to remind you that they don't have evidence that I did anything and they can't identify it. And I want to remind you that I never said these things and I never did these things. And I want to remind you that I have a really strong motion to dismiss. She's just using this as an opportunity to try to remind the judge that there's an outstanding ruling on the motion to dismiss, which it hasn't been that long, Leslie. I've been waiting 4 months on a motion for a summary judgment in a Minnesota case. So buck up, baby. It takes a while. So this is all strategy. And she has these little tiny like footnotes. And if these were actual claims that she had, they wouldn't be a footnote. And this is where she's just able to slander them. That same message, which the Wayfair parties have yet to produce, reveals that Melissa Nathan serendipitously listened to Miss Sloane's phone calls in violation of California wiretapping statute, Penal Code 631. The Daily Mail reporter writes, I had a three-way call with her and Melissa, and she never said anything about it then either. There was, however, never a three-way call that Miss Sloane ever knew of, meaning that either the Daily Mail reporter or Nathan added the other to a private conversation without her consent. Leslie Sloane has known about that screenshot for months. And the only reason she's bringing this up now is because they are literally bringing claims against Stephanie Jones for intercepting messages, which they actually did on Jenny Abel's phone illegally. And so they're trying to claim they're deflecting onto Melissa Nathan that she's the actual wiretapper. And I have a feeling that even though Leslie has her own set of attorneys in this case, that a lot of this is being driven by Ryan Reynolds. And all of this is being driven by Blake and Ryan. They want to get in front of the judge that, listen, I know there's these wiretapping claims, but they're the ones that did it, not us. And that's not how it works. And if it was a real claim, she would bring the charge. But she's not. She's just doing that to slander, in my opinion, and use litigation privilege. It's like, oh, they accused us of that. Oh, well, I'm going to accuse them of that. And we know that Leslie was involved in obtaining illegally discovered documents, right? Like Stephanie Jones was not supposed to give them those private messages, and she did. And so she was a recipient of information she wasn't supposed to have. And so now she's trying to deflect that, no, it was Melissa that was. It's very obvious, and I'm pretty sure a judge will see through it. And then she goes on to say that the Wayfair parties have a Rule 11 basis for their claims, and they should be forced to make admissions rather than hide behind boilerplate objections to clearly appropriate discovery requests. So this part about the boilerplate and the objections that they have, that's standard in discovery. So you have standard objections that you raise on it, and you use the standard discovery objections. So it's standard. But the boilerplate stuff is, again, because they used a boilerplate legal lawsuit, a sham lawsuit, to illegally obtain records from Jen Abel's phone. And they are being sued. Stephanie is being sued for wiretapping. She's being sued for computer fraud. And she's being sued for uh, the data storage, a violation of the data storage under federal law. Serious charges. So they're trying to, again, flip it. This is what PR agents do, right? They try to change the narrative. So she's apparently saying that the interrogatory 3 request, they identify each person you allege Sloane communicated with regarding the Wayfair parties. They have identified at least a couple. The relevance of the interrogatory is obvious given that the Wayfair parties are asserting claims for defamation and false light based on unidentified conversations that she had with an unidentified persons at unidentified times using unidentified words. This would make sense only if they didn't have actual text messages from the journalist from Daily Mail that shared everything that he had with Leslie about this. So she's just, again, trying to get the judge to think that there's no evidence. And they say that they're objecting it under a Rule 33.3 objection. And even if the objection was not waived, interrogatory 3 falls squarely within the scope of Rule 33.3, which permits interrogatories seeking, among other things, names of witnesses with knowledge of information relevant to the subject matter in action and information of a similar nature. They require a response so they can target future discovery requests appropriately. Absent more information, the Sloane parties are unable to assess which, if any, of the potential witnesses among the over 150 individuals and entities listed on their initial disclosures has information relevant to the claims against the Sloane parties. This is truly just silly. Leslie knows exactly who she talked to. Okay. She knows exactly who she spoke to. She probably has it in her emails. She knows what journalists she spoke to. She knows who she tipped off. She knows which outlets she gave information to. And so for her to act like she doesn't know is asinine. And she probably has her own discovery, which is what she's probably having to hand over to them. So this also could be that she's trying to get ahead of it. Like, I'm not getting this information. She would know who she talked to. They also had objections to interrogatories 4, 5, and 7, which they claim are meritless. It's concerning identifying each of the malicious stories portraying Baldoni as a sexual predator, as alleged in paragraph 8 of your amended complaint, and identify each of the stories critical of Baldoni, including that Baldoni was a sexual predator ahead of the film's release, as mentioned in paragraph 282 of your amended complaint. Tellingly, they do not, because they cannot respond. So they said that they would narrow the interrogatory 3 by adding language of, to the extent those communications are relevant to the claims or defenses of actions. They said that their only defense for using Rule 33.3 is because the Sloanes also used the same interrogatory objections. Then she said, during the meet and confer, counsel could not even confirm whether the Wayfair parties are alleging that Miss Sloane even used the word sexual predator or sexual assault in reference to Baldoni. The irony here is that she used it in her motion to dismiss. She said that Blake's allegations constitute sexual assault. It's just so much word salad. What this all comes down to is she wants to know which articles are claiming are defamatory or otherwise actionable. And she said, given the publicity surrounding this dispute and the number of articles written about it in the past year, it would be impossible to complete discovery into allegedly defamatory articles without a set list of what is claimed to be defamatory. Simply put, the Sloane parties need a basic roadmap of the claims against them to prepare their defense and target discovery appropriately, and a response to interrogatories 4, 5, and 7. And she's trying to argue that interrogatories are more practical than depositions, where they seek comparatively simple responses rather than long narrative explanations. And then they're asking the court that if they exceed the scope of Rule 33.3, they must leave to serve them pursuant to the local rule of Civil Code 33.3. So on the flip side, they're saying that they're objecting because they're not going to answer it, because they're saying it's like overbroad and it doesn't it's not narrow enough and it's in violation of these codes. And so then they're like, well, yeah, and I guess if you're right, if they're right, can you give us leave to serve, and I'll get new ones and we'll amend it? The same thing that she claimed and said she would refuse to allow a leave to amend of Wayfair parties. And then she wants them to compel them to produce documents in response to the request for production number 32, which requests documents upon which they intend to rely in drafting a further amended complaint, including but not limited to the documents referenced in their March 6, 2025 brief in opposition to Sloane and Vision PR's motion to dismiss. They have repeatedly represented both in their filings and in the press that they have obtained additional information about the Sloane party's activities that they will add to their amended pleadings. If, as the Sloane party suspect the Wayfair party's representations to the court and the press are lies, they have no additional evidence against the Sloane parties. They should just admit it. I think a judge in that part is going to say it's premature because, first of all, unless they actually file an amended complaint, they don't have to give her any evidence that they have of additional claims. They have said that if they need to amend, they will amend and they have additional information to share. But at this point in time, they don't need to give her everything, and they're certainly not going to give her their smoking guns. A lot of this is that she wants them to say, you're lying, I didn't do this, and you just need to put up or shut up now. It's a desperate effort for her to get out of this lawsuit. That's what this is. Hey, judge, please, please, please file and grant my motion to dismiss. Please, please, please make them put up or shut up, which he can't really do yet at this point. And please compel them to give me this information or else. And then also, if we got it wrong, judge, our bad, give us leave to amend or to reserve them. Now, I want to just show you how hypocritical her requests are because of what she asked them to produce. They actually gave the production document, and some of the requests here are so disgusting. And I just want to preface this that she keeps saying she never called him a sexual predator, okay? She never said that he sexually assaulted anyone. So when they gave responses and objections, he went through it. He did basic objections like on admissibility and relevance and seeking documents out that they don't have, or disclosing information or documents protected by a attorney-client privilege, seeking information and documents that the responding party is under an obligation to any third parties not to disclose. He has a bunch of like objections right off the bat as to why he is objecting to some of these requests. One is like responding party objects to propounding party's requests as irrelevant, overbroad, unduly burdensome, and disproportionate to the needs of the case to the extent they seek information from January 1st, 2019 to the present. That's weird. Didn't the alleged smear campaign start in August? And didn't the judge already say they couldn't have information unless it was from August? So why would she need information from January 1st, 2019, before this was ever really, Blake was involved in this? So some of the things that she wanted was all documents concerning Leslie Sloane, which they object to for a variety of reasons. All documents concerning Vision PR, which they object to for a variety of reasons, but he says he will produce what he has in lieu of those objections. All documents for your allegations in your complaint and amended complaint. And they said they'll provide some, but ones that are privileged or protected. But some of the things here are just disgusting. All documents concerning allegations of sexually explicit or other inappropriate or unwelcome actions and conduct or comments made by Baldoni, Heath, or anyone else during production of the film. Or anyone else? What does that even mean? He's objecting because it's vague. The extent it requires production of documents reflecting trade secrets, attorney privilege, work product doctrine, or whatever. He will provide some documents, but not all these. She wants information on all informal or formal complaints or discussions about the work environment on the set, including the Lively Reynolds parties. And he responded that he would produce some documents, but he objected to a lot. Communications concerning complaints about Baldoni or Heath in any employment setting at any point in time. At any point in time. Talk about way overly broad. I mean, what she's doing here is trying to drown him in she's, like, pissed off. This is my opinion. She's pissed off she's being sued and being brought into this. And so she's trying to just be petty through discovery and just demand everything to drown him in paperwork. All documents concerning allegations of sexual harassment, sexual assault, or unwanted sexual contact by Baldoni or Heath at any point in time. So I thought she said that he wasn't a sexual predator, and then she wants all documents that he sexually harassed and sexually assaulted people. And he will not search for documents responsive to this request. He's willing to meet and confer, but he says that he's never sexually harassed anyone. So he's not going to provide documents. And then all documents, contracts, or agreements with public relations, marketing, publicity firms, or other third-party firms, providers of any social media services, including but not limited to efforts to seed, influence, manipulate, boost, amplify, or engage with social media algorithms, narrative, or virality, as well as the use of bots. And he basically just at the very end says that he did not do this, so he's not going to produce documents, and that it's in violation of like all these different things. And then she wants all documents and actions taken to harm the Lively Reynolds parties, Sloane or Vision PR, and to damage their public image. This is just a really weird request, honestly, because it's very vague. And quite honestly, like, she's the defendant. She's the defendant. She's not the plaintiff here. So she doesn't need these statements. And he says in his response that he objects to the request on the grounds that he disputes that he took any action to harm the Lively parties, Sloane or Vision PR, or damage their public images. So if he didn't do it, he can't produce documents. That's easy. She also wants information on whether he paid for negative material or comments or reactions. And he, again, says that he did not do this and he didn't solicit anyone to do this or to post negative about anyone. So he won't hand it over because he didn't do it. He doesn't have it to give. Also, bot services, which again, he disputes that he did that. So he has no documents that he can provide. She has like all these different ones about bot services, and he disputes it over and over and over again that he does not have documents. There's like 5 interrogatories about bot services. Communication with any media outline of any kind encouraging it to publish negative post, comment, reaction, or article about any of the Lively parties, Sloane or Vision PR. And he says that he did not do that. He says he disputes that he communicated with any media outlet encouraging it to publish negative post, reaction, or article. So what she's doing is she's just like laying on all these negatives, and you can't prove a negative. And so if you can't prove a negative and you don't have documents because you didn't do it, that's really what you have to say is like, I don't have these documents because I didn't do it. And then all documents with current or former cast, crew, colleagues, employees, agents, or other associates of any of the Lively Reynolds parties, including but not limited to communications designed to gather negative intelligence, which he denies doing. Any articles or a copy of any kind of drafted about any of the Lively Reynolds parties, which he again objects because he disputes that he did this and he didn't do it. All of this is just wild, honestly. So she says she didn't accuse him of, sexual assault or sexual harassment, and yet she's demanding that he show her information of that. Here's another one. Any attempt to hide or divert attention away from Wayfair parties' inappropriate, unwelcome, and harassing activity on the set or related to the film, all documents. And he again objected that he disputes that there was any inappropriate, unwelcome, or harassing activities that occurred. I hate narcissists because they just lob these ridiculous allegations and you can't prove a negative ever. So you wouldn't have documents for them. All documents of formal or informal complaints about a hostile work environment. He objected to that. All documents concerning any real, alleged, or reported feud, dispute, or disagreement between any of the Lively Reynolds parties or any Wayfair party regarding filming, editing, production, marketing, publicity, distribution of the film. And he said that he will not search for these documents because it would infringe on privacy rights of third parties, and that a lot of these documents are not within his possession or control. any negative media or social media campaigns against the Lively Reynolds or Sloane parties. So now she's trying to say that it's a smear campaign against her, but she's not suing him. He disputes that he engaged in any negative media or social media campaign against them. All documents concerning efforts to conceal strategies. All documents and communications concerning Baldoni discussing his porn addiction with Lively. I thought she said that he wasn't a sexual harasser or assaulter, and she never said that, right? And he says here under oath, responding party objects to this request on the grounds that he disputes that he ever discussed his porn addiction with Lively. That's the first time we're hearing from him that he didn't have that conversation with her, and that's under oath. All documents concerning him entering her trailer without her consent, under oath. Responding party further objects to this request on the grounds that he disputes that he ever entered her trailer without her consent, and he will not search for documents. Uh, all documents concerning Baldoni improvising kissing or sexual scenes in the film, he again denies that this happened whatsoever, and he will not search for documents. And then all documents and communications concerning Baldoni having sexual contact with a third party without her consent. They want him to be a predator. Can you imagine? Literally only to humiliate him and further slander him. He disputes that he had sexual conduct with any third party without her consent. He will not search for documents. Even if he did, it's not even relevant to this case. All documents, including the identities and locations of participants included in the text messages appearing in 193 of the amended complaint. He says he doesn't have those documents in his possession. And all documents upon which you intend to rely in drafting a further amended complaint, including but not limited to documents referenced in your March 6, 2025 brief in opposition. And so here's the thing. She has this whole motion to compel, and this is the crux of what she wants. She's not fighting that he's not going to give her documents about sexual assault. She's not fighting that he's not going to hand over documents that he sexually assaulted someone without their consent, or that he sexually harassed, or that he led a smear campaign. She's not compelling the court or asking the court to compel any of that, right? All of those things I just read to you, where of all of those obscene asks that she asked about and demanded that he hand over, which he objected to, she doesn't want the court to intervene in that. She wants them to intervene in what might implicate her down the line. That's what she wants. And they stated that it's overly broad, unduly burdensome, and that it requires them to produce documents upon which you intend to rely on in drafting a further amended complaint. They say that it's protected under attorney-client privilege, work product doctrine, and it's premature because they haven't filed it, and they're not going to hand over those documents. She went to a judge for that reason and that reason only, because she's probably terrified about what they have on her. But all those other things that she's demanding that he hand over, she didn't have a problem with him objecting to. Oh, so you didn't harass anyone? Cool. So you didn't run a smear campaign? Cool. So you didn't have bots? So you didn't harass Lively? So you didn't improvise? That's fine. Great. I don't care. I don't need those documents. I just need to know what you have on me. And she's panicking about what he has on her, because that's the only thing she asked the judge to intervene on. They should answer the request for production on number 32. That's it. That's it. Because she is panicking, but she's flipping it and acting like they don't have any evidence on her. And I bet you they do. There's no way they're lying. The only ones that have been proven to lie in this entire situation are Leslie Sloane, Blake Lively, and Ryan Reynolds, and Stephanie Jones. Thus far, Wayfair has brought all the receipts, and Miss Sloane, all of the documents are in the amended complaint. And you're gonna, have fun with this motion to compel. I have a high suspicion that Wayfair is going to respond very harshly here. And under grounds, it's premature, overly broad, and she is doing this in for strategy to try to get ahead of the judge, to hey, dismiss me. And all of this, by the way, Leslie is still the PR agent for Ryan and Blake. And so on the one hand, she says, Baldoni, you're not a sexual predator, but please give me all your documents that you are. And then on the other hand, everything that's come out the last few days about the illegal subpoena, the Sham lawsuit, the wiretapping, She's trying to deflect and get something in the court docket for PR purposes to bounce it back on Baldoni like he did it too. But the odd thing is that he didn't do it because she's accusing Melissa Nathan of it, which Melissa Nathan, the last time I checked, is not Justin Baldoni. So I keep getting more and more disgusted by how they're acting. I hate that he is involved in this because it's so painful to be on the receiving end of a lawsuit like this when you are up against malignant narcissists that are sociopathic and have no remorse and do not care about the truth. It's going to be a long road, and the interrogatories and the production of documents that she's seeking are really done to harass him and to like overwhelm him, to make him get fatigued and to drop the case against her. So if she can't get a judge to dismiss, she's going to try to like fatigue him through all these filings. And again, this motion to compel is another example of how they will abuse the court to paint him unfavorably and try to like win the PR. That's just my opinion. You are entitled to yours. Again, I'm not a lawyer, but I'd love to know what your thoughts are here. Make sure, if you could, give this video a thumbs up. Make sure to subscribe to my channel if you haven't subscribed, and click the bell so you never miss a video. Thanks so much for watching. Bye, guys.